Hello, this is Tom, aka Gedeon, here for Tabletop Tap Room. And we have some more documents that have been posted in the court case that is Wizards of the Coast, TSR LLC versus Wizards of the Coast, and some interesting developments. So I just thought we would review United States District Court, Western District of Washington at Seattle. Reply in support of the motion for preliminary injunction. And I just want to point out here that TSR LLC, Justin Lanassa, and Dungeon Hobby Shop Museum are the counterclaim defendants. You're going to see this phrase, counterclaim defendants, repeatedly. Now, this is their response to the response that Justin Lanassa's and TSR's lawyers. So again, here I have put TSR. I have added this TSR and to counterclaim defendants. Just keep that in mind. Counterclaim defendants are Justin Lanassa, TSR, Dungeon Hobby Shop Museum. And so we have this statement here that they admit Wizards has used Star Frontiers and the TSR marks in commerce since before the counterclaim defendants used the marks or registered them to the United States Post Office and Trademark Office, which establishes Wizards' rights and the marks are superior. They admit it, right, in their filed brief, their filed declaration. Also, they admit Wizards has evidence of consumer confusion, even though they quibble about its significance. So they admit, yes, Wizards has evidence of consumer confusion. Counterclaim defendants maintain an argument that the version of SFNG upon which Wizards relies, which this reply calls the subpoenaed SFNG, is not the real thing. Down here, we get this statement, even if they are correct about the provenance of the subpoenaed SFNG, and that is doubtful. I love that phrase. Based on the metadata, the metadata associated with the document, they do not and cannot dispute that the document was distributed publicly only because the counterclaim defendants, that would be TSR, were developing SFNG. And in any event, the document the counterclaim defendants submit as the actual SFNG, known as the Lanassa SFNG, still contains offensive content. Okay, let's scroll down. Counter defendants use Wizards marks and the counterclaim defendants use Wizards marks in commerce. Counterclaim defendants use the SFNG listing on the museum and the TSR LLC websites displayed merely as a digital mock-up and not an actual product that could even be potentially offered for sale at this point. But they do not and cannot dispute that sales, marketing, and distribution of the SFNG, the activities Wizards asked the court to enjoin, would constitute use in commerce. So they market, they market, they offer to distribute, and they offer it for sale, but they don't dispute that that would be use in commerce. They dispute that they've done that yet, but they're saying, well, we haven't done that yet. But they don't dispute that it would be use in commerce. But their own TSR disputes that they have not actually sold or marketed or distributed copies of the SFNG, Star Frontiers New Genesis. But their own filings with the U.S. Post Office and the Patent Office state that they intend to do that. It's an important distinction. That the counterclaim defendants have not yet reaped any commercial benefit from SFNG makes no difference where they plan to do just that. Well, we haven't reaped any commercial benefit from it, but they plan to do just that. That has been well established. Wizards has established that the counterclaim defendants' use of the mark creates a likelihood of confusion under the sleek craft factors. Now, the sleek craft factors are this. There was a case involving a company named Sleek Craft versus another company. And these like 8 factors were established in law through that precedent. And we're going to see that here in a minute. And at least 5 of them really just trounce TSR. So the sleek craft factors are important, and we're going to see that. But it's from a previous precedent. So they're referring to that. But this precedent's so important that they just refer to it as the sleek craft factors. And it's like lawyers and judges know what they're referring to because it's so well established in law. And we're going to get to that in a second here. Scrolling down some more. The counterclaim defendants argue that the CBWJM post in the thread called "Does TSR3 Have Nazi Connections?" shows consumers are aware of the distinction. So counterclaim defendants, TSR, is saying that this post that's titled "Does TSR3 Have Nazi Connections?" shows that consumers are aware of the distinction between TSR LLC and TSR Inc. But the post on its face attributes that clarity to the 3 added to TSR. This proves Wizard's point. Without the 3, which TSR itself does not use on the SFNG cover or elsewhere, nothing apparently would distinguish TSR LLC from TSR Inc., on whose reputation it trades. So they're trying to say that this post concerning does TSR3 have Nazi connections establishes that consumers are aware of the distinction, yet they don't use the 3 themselves. And Wizards of the Coast is saying, look, that on its face establishes that there is confusion, because without the distinction of adding the 3, TSR3, people don't know what you're talking about. You have to add the 3, and yet TSR LLC does not include the 3 in any of their logos or marketing. And a little bit more here. And while Wizards' third example shows commentators correcting an original poster, so some of us, i.e., that would be referencing people like Eric Tenkar, maybe myself, correcting an original poster with the accurate information that TSR LLC is not affiliated with Wizards. This again proves the point. The original post shows confusion that other consumers must correct. And good job, Eric. Standing up and pointing it out. Good job, Eric. Wizards need not prove that every consumer was confused, only that there is a likelihood of confusion. So some consumers are not confused. That would be like people like myself, Eric Tenkar. I could name others, but we are prominent figures in this. Some of us are not confused, but we must point it out because there are some who are confused. There is a likelihood of confusion. Counterclaim defendants also argue that the new and modern look and feel of the SFNG mockup, as well as the passage of time since the last edition of Star Frontiers was released by TSR Inc., somehow minimizes the risk of confusion. But they offer no support And the sleek craft factors or any other precedent for why that is so. This issue is not that the products look the same. The issue is that the counterclaim defendants have created and are promoting an all-new return of Star Frontiers using the marks belonging to Wizards. All right, now sleek craft factors. All right, and we'll just read this and you'll get it. Strength of the marks. The marks are arbitrarily or fanciful, the most distinctive categories that receive the most trademark protection. Okay, that one's a little not necessarily so straightforward. Proximity and relatedness of the goods. Counterclaim defendants sell RPGs, exactly the same kind of products as those which the Wizards licenses its marks. So this is a factor that causes confusion. The proximity and it's an RPG. We're selling an RPG. It's not like Wizards of the Coast sells RPGs and TSR sells boats, okay, or sells hammers. Well, there's no confusion because the TSR LLC is selling Star Frontier's hammer. It's a tool. It's completely different than, no, they're both RPGs. Types of goods and customer care. New players and other customers encounter RPGs in various settings. And the low price point means purchasers are less likely to exercise, purchasers are likely to exercise less care, thus making confusion more likely. Again, if this was a boat and you're spending $7,000, you would use more care. But because it's a game and you're only spending $60 or $70, the price point's much lower. You're not as likely to scrutinize. Similarity of the marks. The marks at issue are identical. It's going to cause confusion, which is what Wizards is alleging. Marketing channel convergence. Both Wizards and the counterclaim defendants market and advertise products in similar channels. So these are like 5 of the 8 factors. And then they allege these factors all indicate the consumers are likely to be confused by the counterclaim defendants' use of the marks, even without any showing of actual confusion. They're saying these factors make it likely there will be confusion. We don't even have to prove that there's any confusion. That was one of the things that in the declaration from TSR was, they can't prove that there's any confusion. We don't have to, is what they're saying. The sleek craft factors make it clear. Confusion is likely because of these factors. 5 out of the 8. We don't have to show any confusion. Confusion's likely based on established law. Continuing, that Wizards has evidence that consumers actually were confused only further supports the conclusion that consumers are likely to be confused. In Lanassa's own declaration, he actually stipulated to confusion of consumers. He actually admitted to it, to confusion of consumers, and the Wizards of the Coast lawyers is calling him on that. And Wizards has shown Washington use of the marks. They claimed in their declaration, counterclaim defendants argue that only Wizards argue only that Wizards has not established a claim under the Washington law because the statute deems a trademark to be used in this state when it is placed in the ordinary course of trade on goods sold or otherwise distributed in Washington. So under Washington law, if the goods are sold in Washington, then that trademark is used. and they're trying to claim, you can't prove that it was sold in Washington. Well, guess what? I have another PDF here. This one is a supplemental declaration of Elizabeth Shue in support of Wizards of the Coast, LLC, motion for preliminary injunction. And this is Elizabeth M. Shue is an exec at One Bookshelf. One Bookshelf, here she declares, One Bookshelf has sold more than 50,000 units of D&D classics, classic titles using the TSR mark in Washington since 2013. They have sold 50,000 of the TS units, publications, using the TSR mark for D&D. And this includes various Star Frontiers titles, which both bear the TSR mark and the Star Frontiers mark. For example, One Bookshelf has sold nearly 2,000 units of Star Frontiers Alpha Dawn into the Washington market since 2017, with sales occurring in each year from 2017 through 2022. So 2,000 units of just Star Frontiers Alpha Dawn sold in Washington State over the course of 5 years. Now, what does that tell me? That tells me that there's at least 2,000 fans of Star Frontiers in Washington State. I'd like to know why the hell they don't have a Star Frontiers convention in Washington State, but that's a topic for another day. So, going back to the main declaration here. So this was their big thing. You can't prove you sold any. You can't prove it was used in commerce because you haven't sold anything in Washington State. They have a declaration from an executive of One Bookshelf saying, yeah, we've actually sold 50,000 units in Washington State, and 2,000 of them have been Star Frontiers. Alpha Dawn rules. Okay. We're almost done. There's only 17 pages to this. We only get page 15. We're on page 11. Counterclaim defendants spend a bulk of their brief on a sideshow. Whether the version of SFNG on which Wizard's motion is based is authentic. Despite its provenance in the response, this issue is of minimal significance to the question before the court. To begin with, the counterclaim defendants do not dispute that there is a presumption of irreparable harm, and they fail to rebut it. They don't dispute that there's irreparable harm, and they fail to rebut it. Boom. First, the available metadata evidence indicates that the subpoenaed SFNG originated with counterclaim defendants. Remember how it was Photoshop? Doesn't matter. The metadata shows that it originated with the defendants. And they're calling them on it. And let's scroll down. And now this gets bound to the Dave Johnson declares. Dave Johnson had a supplemental declaration that was filed by TSR's lawyers. And while Johnson in particular attests that he did not distribute the Google document version of the SFNG game to anyone except for Mr. Lanassa at any time, they cite Johnson declaration, page 6, the subpoenaed SFNG and emails produced by Samora cast doubt on this story, if not undermine it entirely. That is polite lawyer speak for Dave Johnson's a effing liar. They just called Dave Johnson a liar. Actually, that was polite lawyer speak for Dave Johnson perjured himself. That's how I interpret that. Subject to reasonable dispute. So they're getting down to some nitty-gritty here. Subject to reasonable dispute or authenticity and substantive validity did not suggest failure to conduct reasonable inquiry. They were alleging that they didn't do reasonable inquiry. They're saying all this, you can dispute it, but that doesn't mean we didn't do reasonable inquiry. In any event, as described above, the subpoenaed SFNG metadata links, links it to the counterclaim defendants. Second, if the counterclaim defendant's version of events regarding the subpoenaed SFNG were true, their activities caused its dissemination and infringement of the wizard's marks. They're saying, sure, all right, let's suppose that their version of the details are true. Doesn't matter. Their activities caused the dissemination of the fake version if the fake version is fake. But we're not buying that it's fake. Counterclaim defendants do not directly contest the possibility of reputational damage to Wizards. Okay, Wizards is saying we need this injunction because it's going to damage our reputation. They did not counter that possibility in their argument. Indeed, they concede that the subpoenaed SFNG contains offensive content which they disclaim. See Johnson Declaration, page 8, and the Lanassa Declaration, pages 25 and 22. But regardless of whether the counterclaim defendants created the content and the currently available document metadata indicates that they did, or it was added by somebody else, that material only became public and posed a risk to Wizards' reputation due to the counterclaim defendants' use of Wizards' marks. They argue, SFNG, now this is the piece de resistance of this whole argument. They argue that SFNG has never been available for sale to consumers in the marketplace, and the counterclaim defendants have not sold or attempted to sell a single copy of the SFNG game to anyone. They're saying it has never been for sale in the marketplace. We have never attempted to sell any. So, enjoining the counterclaim defendants to preserve the status quo will not harm them in any way. That is what we called in high school a scoop slam. Scoop slam. You're claiming that it has never been available for sale and that you have never attempted to sell this game. Fine. Then maintaining the status quo will not harm Wizards of the Coast. So therefore, we should get the injunction. They've taken their own assertions out of the declarations that Justin Lanassa made and Dave Johnson made, and they're just spinning them on their. They're saying, "Look, all right, fine. We'll take them at their word. They've never sold it. They've never attempted to sell it. It's never been available for sale. So there's no harm in having this injunction, barring it from being available for sale. We will maintain the status quo through the course of until the lawsuit is settled." So that was just brilliant. That was absolutely brilliant, and had me laughing throughout how they spun their own arguments against them out of Justin Lanassa's own declaration and the Dave Johnson declaration that they very politely stated was a lie. That they in very polite lawyer speak said, yeah, he just perjured himself. Oh my God. I needed a good laugh. It is late at night, and I was supposed to go to bed 30 minutes ago. And I was going to go to bed, and Tammy was like, "No, you have to do the video. You got to do a video now. It's breaking news." So here we are. What is it? 12:25. Now Saturday morning, effectively, and I'm about to edit this. So I'm going to sign out here. This is Tom from Tabletop Tap Room. That is a response of Wizards of the Coast lawyers to Justin Lanassa's declaration and Dave Johnson's declaration, basically calling them liars and going, all right, irregardless of what you said, there's no harm in us getting this injunction. Oh my goodness. All right. So that's the news. They called Dave Johnson a liar, basically claimed he perjured himself. They turned Lanassa's declaration on its head and said, well, all right, fine. You didn't dispute this. You didn't dispute this. You didn't dispute this. Therefore, you're basically admitting that confusion is likely. You're basically admitting that we do have evidence of confusion. You're basically admitting that you've submitted a copy that has racist and sexist content that we find abhorrent, and you basically admit that there are consumers who have pointed out the confusion to other consumers. So therefore, we don't have to prove that every consumer is confused, just that confusion is likely. And then there's the sleek craft factors, which I didn't know anything about until I read this. But 5 out of the 8 of them demonstrate the confusion's likely. And we don't have to prove confusion. We just have to look. The factors demonstrate that confusion is likely. So I'm betting, and I don't bet very much, but I'm betting that the injunction is going to be passed. That Wizards of the Coast has made its case on the preliminary injunction, and Justin Lanassa is on the face of it and on the law and the legality and all the evidence put forward and the declarations put forward, including the perjured declaration, the apparently perjured declaration of Dave Johnson, is going to get their preliminary injunction. And TSR LLC will not be allowed to market Star Frontiers material. Now they continue to market their Star Frontiers playing cards. We'll see what happens with that. But I think the injunction is going through. So this is Tom from Tabletop Tap Room, signing out, thanking you for watching my video. Thank you. I want to thank my subscribers. You guys are great. I love you guys. Appreciate you. And if you've not subscribed, please consider hitting the like, subscribe, and bell icon to help me build the channel. And until then, keep on gaming, just not with TSR LLC products.